Okay, everybody, welcome to the Los Angeles chapter of the California Receivers Forum Luncheon Education Program. This is our fourth and last education program of the year. First of all, we just want to thank everybody for coming out and supporting this organization and supporting this program. I promise you today is going to be a very interesting and education program. Also, Tony wanted me to mention that right now we're putting together the directory for the California Receivers Forum membership directory. That goes out to many of the judges in California. How many judges do we send that out to?
Send it to about 700.
About 700 judges throughout the state of California. There's ways to get your name in there, advertise your business. I use that directory often when I'm looking for specific counsel in specific region, or I'm looking for different types of vendors in that region, because it breaks it down by different regions all throughout California. I think it's a great resource because, like I said, the judges have it, and it's something for them to look at. And if they want to cross-check you to see if you're part of an organization, they can look at that directory. So I highly encourage you to be part of that membership directory. Also want to let you know, after 10 years and hundreds of luncheon education program, I'm finally turning over the reins to a new generation of young and vibrant people who are going to be putting on these luncheon education programs in 2018. Ben King of Loeb & Loeb is going to be the head chair for the education committee. So if you have any ideas or thoughts for programs that might be good for this organization, please reach out to Ben King from Loeb & Loeb. So today's program is Minority Interest in Commercial Real Estate. Learn how to value and sell in a receivership and a bankruptcy. The program is being put on by Todd Wool from Braun Properties. Todd is a real estate broker. We've used him on many of our projects, and he always exceeds our expectations, comes up with very creative ways to market the property, and most importantly, makes you look good with all parties and attorneys and judges. So Todd will be on the panel today. Joel Weinberg of Insolvency Service Group is the second member of our panel. And then James Hill of Sullivan, Hill, Lewin, Rez, and Engel is also here as well. So you have a very knowledgeable, experienced panel, and I look forward to hearing their presentation today along with all of you. So let me turn it over. Thank you.
Kevin, thank you. Despite the title that went out in the announcement, the program today, we're going to discuss a little bit broader concept. In addition to fractional interest in real estate itself, we're also going to expand the discussion to minority interest in the business entities, which in turn may own real estate assets underneath. So we'll be talking a little bit about limited liability companies, closely held corporations, limited partnerships, as well as tenants in common and other fractional interests in real estate. So as an initial consideration, if you're appointed a receiver or representing a receiver, the first consideration is what is the nature of the interest that is the asset of the receivership estate. And in most instances, some of the more problematic areas will arise with LLCs, but what you have to do when you're evaluating these assets, you have to look at the state of formation in the case of an entity. So if you got a Delaware corporation, you got to look at Delaware corporate law, or a California LLC, you got to look at California law that regulate the formation and any restrictions that might exist on the transfer of those interests. So with regard to limited liability companies, which is really probably the most dominant form of entity that's used in real estate investments these days, you have to look at the nature of the interests, which will be governed again by the law governing the state of formation of the LLC. And typically that law will also provide for the efficacy of restrictions on transfer of interests or buy-sell arrangements or things that may restrict the ability of the receiver to sell or transfer those rights. And you also have to look at the key documents that exist with regard to LLCs to determine what those rights are, what are the nature of the interests that are the property of the receivership estate. So you'd look at the operating agreement, the articles of formation, and sometimes there's even separate buy-sell agreements that may be freestanding outside either of the two documents. So it's important you get the universe of documents, understand the nature of what you have to sell. Similarly, with closely held corporations, again, you want to look at the law of the state of formation. You want to look at the articles, the bylaws, any shareholder agreements, any restrictions that may exist on the share certificates themselves, and also probably consult with a securities lawyer to make sure there aren't any securities laws restrictions on the transfer of shares. And with limited partnership and general partnership agreements, again, you look to the state law under which the partnership was formed, but there you would look primarily to the partnership agreement, whether it's a limited partnership agreement or a general partnership agreement. And finally, with regard to fractional sales interest in real estate, of course, you look to the law of the state where the real property is located to determine what is the nature of the interest. As you're probably all well aware, one of the more common vehicles today in investing in large real estate projects is selling off small fractional interests where you might have a dozen or more entities owning small fractional interests as tenants in common in a piece of commercial real estate. Jim, what are some of the common sorts of restraints that you'd find either with LLCs, partnerships, in terms of restricting the transfer of an ownership interest?
Yeah, well, one of the ones we see often in either LLP or LLC entities is a right of first refusal. In other words, don't sell outside of our group. If you're going to go try and sell this interest, you need to sell it back to our group or sell it back to the entity itself. But you'll also see all kinds of restrictions where people get real creative on transfers. Everything from a required discounted buybacks based on the actual capital, the actual book value. Things that are not necessarily tied to the real market value of the underlying property. And those are the kinds of restrictions that we find as the biggest challenges if we're representing a receiver or a trustee or a debtor in possession in a bankruptcy case. If we have a piece of property, in the estate that's fractionalized interest or a minority interest in one of these entities, and we're trying to figure out how can we get maximum value out of it. And as Joel was saying, we start with the premise that the estate, the trustee, the fiduciary is going to get whatever the debtor had and know better. So we better drill down and find out, well, what is exactly there. Maybe some receiverships have judges who are more expansive in their interpretation of what they can do, but I think we're all in agreement up here that in receivership cases, there are less tools available to make a minority interest more marketable than compared to bankruptcy. And the reason I say that is several. One, in bankruptcy, when you're selling an interest, if you can get the court to determine that the restriction on transferability is what is referred to as an ipso facto clause, like is referred to in Bankruptcy Code Section 363L, a restriction that the court believes is unduly restricting the alienability of the share or the interest, it might not get enforced at all. And there's a lot of debate on when it's ipso facto clause and when it's a clause a restriction on alienability that will be enforced. One of the things, I don't know if we're right at the point where we're going through bankruptcy as a
We haven't quite yet.
yeah, but those are the primary restrictions that we find as our biggest challenge.
Yeah, one other thing that's kind of more unique to limited liability companies is that oftentimes if a member seeks to transfer an interest without the consent or outside the four corners of the document, sometimes there's an event of a dissociation. And so that what the transferee gets isn't what you think they're getting, and you have to be very careful here. For an example, they may not have any voting rights. They may not be entitled to any interim distributions, and in fact, that interest may only be entitled to receive a distribution in the event of a liquidation of the underlying entity. So you have to be very careful, depending on the state law that you're dealing with regard to limited liability company interests. And I think the important lesson is when you're talking about sales through a receivership, I think that the receivership courts are going to be more restricted by what applicable state law is in terms of the transferability of the interest, enforceability of the restraints on the transferability of those interests. Whereas in bankruptcy, there may be some ways around those problems, and we'll get to that in a moment. Yes, Alan?
Yeah, quick question, Joel. So you're saying that typically a receiver will be governed by the restrictions, like in an operating agreement, it says the sale to anyone outside is only of a voting, of an economic interest, not a voting interest. There's no way around that, whereas in bankruptcy,
Maybe.
some of you.
There may be.
Maybe. There's a big maybe on that.
Yeah.
But I mean, you might be able, to persuade a receivership court as a court of equity. If you have one of these situations where the only members in the LLC, for example, are all insiders, and and they're saying, well, look, there's no reason then, and maybe there's some other creditors or some other party in interest that could have has an economic interest if it's sold at the highest value. In those cases, you might be able to persuade the court that the restrictions on forcing the other members to have a non-consented member substituted in don't really apply, and therefore we're not going to enforce that. You might convince the court, maybe, but generally you're right. I mean, you're going to be stuck with the restrictions.
And I think we're in agreement that it's very fact intensive. Are you talking about a minority interest in a 6 to 10 member organization? Or are you talking about a minority interest in a several hundred member organization? And as a practical matter, how much is, how important is that individual in the mix as a whole? And I think that's a practical point in a bankruptcy or a receivership.
Yeah, and before we move to bankruptcy, so you really have a couple of issues that that you have to consider. One, to what degree do the restraints on transfer apply in a receivership versus a bankruptcy? Two, is it possible, either in a receivership or bankruptcy, if there are problems with selling that interest itself, can you nevertheless force the sale of the underlying property in its entirety, and whereby the receivership estate or the bankruptcy estate would then get its pro rata portion upon the sale of the entirety? And that's probably something that's not going to happen in state law, but could happen in a bankruptcy. So having said that, Jim, why don't we take a look at what would happen in bankruptcy by comparison?
Okay, well, I just want to make sure we hit some of the restrictions and compare receivership to what is likely to happen in a bankruptcy, where I think we have an argument in bankruptcy, it's the opposite outcome. One, you mentioned a provision that might call for the dissolution of the entity upon certain events, and a receivership court may have to give effect to, a judgment return not satisfied, events of insolvency, a failure of performance on capital calls and the like, a forced dissolution. That may be a real challenge for a receiver. Another one would be a discounted buyout clause, as I mentioned earlier, that's based on maybe capital paid in rather than market, or already defined formula for buyout, and again, the exclusive rights of just a few people to buy. And I think each of those are, have a potentially different outcome in bankruptcy. Number one, I think that the first one I mentioned of a forced dissolution upon certain events like insolvency or filing a bankruptcy or some failure of performance conditions, they may not be enforced in bankruptcy because they're a classic ipso facto clause.
Well, let's break the bankruptcy. I think we should. There's a couple of gating issues you have to look at. So the first question is, when there's a bankruptcy filed, is notwithstanding all the restrictions in the interest, whether we're talking about a membership interest in an LLC, a limited partnership interest, and so forth. First question is, does it become property of the bankruptcy estate? And I think many courts are uniform in holding that, yeah, it does. I mean, it may be subject to all kinds of limitations, but those limitations, such as an insolvency event, ipso facto clause, doesn't preclude that property from becoming property of the bankruptcy estate. The real question is, all right, now it's property of the estate. What can you do with it? And can you get around those restrictions?
Okay, if you want to back up, well, then to what do you have in a bankruptcy case? Well, an initial question we always ask when we're, say, representing a trustee on these limited partnership, and even LLC interest is it an executory contract or is it not? And courts are split on it, and they're also say it's very fact-driven. Okay, so in other words, if I have an interest in an LLP and my membership requires me to participate in management, and my interest requires me to respond to capital calls, and there's a plan for development of this property, and I have some active participation in it, it's more likely than not that that's going to be determined to be an executory contract. That can be good for a debtor or a trustee, because then you have an ability to assume and assign and pass on that interest to a buyer with some very powerful provisions in the code under Bankruptcy Code Section 365. You can cure certain defaults. You can transfer, and with a finding of assurance of future performance by the assignee, you relieve the debtor of any future obligations. So it could be really good. But a practice pointer for anybody in here who's represented a trustee in bankruptcy, and you have something that looks and smells like an executory contract, if it's in a 7, you've got a real short period of time to assume that contract, or it's deemed rejected. 60 days under 365D. 60 days. And as you know, when you get appointed in these cases, things go fast. And so if it's executory contract, you either want to assume right away, or you want to get an extension of the time to assume. If you get an extension of the time to assume, guess what? You may be obligating the estate as an administrative priority claim to pay those capital calls on an ongoing basis. So it's a real important analysis, quick, early in the case.
Yeah, one thing too that's important to distinguish here is how courts will treat the different kinds of interests. I think with corporate minority interests in corporations, not a big conceptual problem.
Yeah.
It's probably going to be treated as an asset subject to whatever securities limitations might exist on the transferability. Limited partnerships, general partnerships, again, not difficult for a bankruptcy court to deal with. They're going to treat it primarily as an executory contract. And the case law is somewhat more consistent there. Limited liability companies is the one area where the bankruptcy courts have struggled, and the case law is all over the place on whether those interests can be transferred. Is it an executory contract or not? I mean, most courts agree it becomes property of the estate, whether they're going to go down the executory contract analysis or not. But then what you do with it, it just depends. It's like Jim says, it's very fact intensive. And the other thing with regard to the last category of things that we're talking about, which are fractional interests in real property themselves, such as tenant in common interests, the bankruptcy court does offer some very powerful tools that certainly don't exist as a matter of state law, or much more difficult to get there.
Yeah.
So
Well, I was just going to conclude on the executory
Go
contract
ahead.
discussion. We often don't want it to be an executory contract. We often want to say it's non-executory because it's like what Alan pointed out. No, it's an interest mostly in the profits and rents that are going to get generated here, and that's all we're selling here. And we as a trustee don't have an obligation to do anything material with that interest when we're selling it. We're just trying to sell the interest. And in the materials that we prepared for the program, we attached some pleadings and orders from a case that we ran in Nevada where we were selling a mix of LLC, limited partnership, and other partnership interest using Todd's company, and again it was more, we were selling that right to income, that right to value, that capital, and we were able to avoid fights about was it already a rejected executory contract and the like.